All right, good morning. Thank you for tuning in to Facebook Live to have your questions answered by Belal Hamideh. As ever, glad to be joined by Belal. How you doing this morning?
I'm great, Greg. How are you doing this morning?
I'm doing good. I'm doing good. Of the two of us, one of us did not shave intentionally. I just more or less forgot myself. But yeah, but no, I'm glad to be here. I got the new background. That you're looking good. I like the sport coat. I like that design. So yeah, so cool, cool, cool. All right, well here we'll jump into it because folks have sent in some questions. All right, here. So the first question coming in from the people is, excuse me, can I file for workers' compensation if I get COVID-19?
All right, well, that's a great question. Obviously, there's a surge going on with COVID. We're hitting, in the entire United States, positive tests like in the 200,000 range per day.
Mm,
So
mm.
people may think that, hey, maybe I got COVID at work. If I'm missing time from work, am I entitled to get payments from my employer or is it on my dime? So generally speaking, if you want to get workers' compensation payments while you're off of work, you have to prove that your injury was caused by work. Now, with
Mm.
COVID, that's going to be a difficult thing to prove, definitively, because you could have got it in multiple places. And you can assume you
Oh,
got it at
geez.
work, but you have to prove that. However,
Oh, man.
like I said before, California has some of the best workers' compensation laws, and Governor Newsom actually put Senate bills into effect so that there
Oh,
are presumptions created that you actually did get the COVID from work in certain
oh,
situations.
wow.
So there's actually a new Senate bill, 1159, that just came out, and it says
Mhm.
that if you're a first responder, or if you're a healthcare worker, or if your employer has 5 or more employees and there's been a recent COVID breakout
Mm.
or outbreak, then there's
Mhm.
actually a rebuttable presumption that's created that you actually did get COVID at work. And instead of
Oh,
you having to prove that you got COVID from work, your employer now has to rebut that presumption, and they actually have to prove, if they want to dispute that you didn't get COVID at work. So that's how a rebuttable
huh.
presumption works. Instead of you having to do the work to prove that you got the COVID at work, the employer has to do the work to prove you did not get COVID at work. And they have to rebut the presumption that you will win your claim. There is also a previous Senate bill which covers the period before September 2020, where other types of workers are also presumed to have gotten COVID at work if they are within a certain category of employees. One of those categories
Mm.
of employees is grocery store workers. So if you're a grocery store
Ah.
worker and you have unfortunately gotten COVID, the Senate bill actually presumes the COVID was caused from work. And then your employer, whichever store you work for, has to prove you didn't
Mhm.
get it at work, which would be a very difficult thing to
Mm.
prove. So
Yeah.
I would suggest that you could just look up online Senate bill related to COVID for work injuries, and then it'll have a complete itemized list of all the categories of workers where they are presumed to have gotten COVID at work and will be presumed to be entitled to workers' compensation money.
Wow. I mean that no that's a that's a great answer. I mean, every time we do this, I'm always struck by how I just assumed with a layman's knowledge that the worker has no options and that they are out of luck. And every time we talk, it's I mean, while these are difficult subjects, there's always something reassuring about the way that you bring up there is some action they can take. There is some thing they can try or do. That's really good to hear. That's frankly really good. Yeah. Great. The next question is, how much workers' compensation disability payments can I get while I'm unable to work?
Okay, that's a great question. So there's a variety of different types of injuries you can sustain at work. Some injuries you return to work full duty and you do not miss any time from work. Some work you have to work with restrictions, and sometimes the employer cannot accommodate the restrictions, so you end up not working and not receiving money. And then the third type of restriction you can receive after an injury is you cannot work at all with or without restrictions. So in the last two
Wow.
situations, when your employer cannot accommodate your restrictions and you're unable to work, or if you're unable to work at all, you're entitled to disability payments. So you can receive up to 2 years of temporary disability payments while you're off of work, and it's calculated. You get a check every 15 days, and it's calculated 2/3 of your average weekly earning. So if you were making $1,200 a week, you would be entitled to $800 a week in disability payments, and you would get a check every 2 weeks. So your check would be for $1,600. And there's also a maximum amount that you can receive per week, depending on the year that you were injured. But to answer the question, you receive 2/3 of your average weekly earning for a maximum of up to 2 years.
Oh, that again, that's still more generous than I thought. That's good to hear. And the third question, no, seriously, I mean, the third question is, if my primary treating physician released me to work full duty, but I don't agree, how can I contest that report?
Okay, so when you do get injured, if you need to seek medical treatment, you are sent to a doctor who's going to be the primary handler for your injuries. You see them at least every 45 days, and they're called your primary treating physician. At some point, the primary treating physician is going to have an opinion that you can no longer benefit from more medical treatment and that your medical condition has plateaued. So what they do is they write a report indicating how much disability percentage you have. And that disability percentage is going to affect the value of your case. Now, they do not always correctly assign a disability percentage. They have to follow the American Medical Guides, 5th edition, and a lot of it is up to interpretation and is subjective. And if you have a primary treating physician who is not very employee friendly and unfortunately is more employer friendly, they can kind of downplay your disability percentage. So if you receive a disability percentage from them, or you believe that they prematurely declared that your condition cannot get any better, you can actually contest that opinion and you can request an evaluation from a qualified medical evaluator. And they are appointed by the state. It's a list of 3 doctors that get sent down. The employee strikes one off, the employer strikes one off, and the one who is remaining will evaluate the injured worker one time, and they will evaluate all of their medical records and then provide their own opinions. And you can use those opinions to contest the opinions that you didn't agree with that were given to you by your primary treating physician.
Okay, so there are steps a person can take in that, should that happen. Good. The fourth question ties into the first one we had there, which is how much is my case worth if I do get COVID-19 at work?
Okay, so a workers' compensation settlement at the end depends on whether or not you've had any permanent damage to your body. Now, you can open up a workers' compensation claim and you can receive benefits while you're off of work or while you need medical treatment, but that doesn't necessarily mean you're going to get a settlement payout in the end. In order to get a payout in the end, you generally have to show that you have sustained permanent damage. Now, the overwhelming amount of people, thank God, that get COVID don't have any permanent damage. However, permanent damage can arise in two ways. One is the COVID can leave the person's lungs or internal system or respiratory or cardiology systems impaired. And if there is permanent impairment left from the COVID infection, you may be entitled to a settlement payout after you've received disability money for being out of work temporarily. Aside from that, this is in regards to whether you can get a settlement, which is a payout for permanent damage. So the first type of permanent damage is you're still living, but you're not the same person that you were before. You have impairments that you did not have before. And the second, more unfortunate permanent type of damage is a resulting death from COVID. If you have a death from COVID, a dependent or spouse can file for workers' compensation death benefits on your behalf. And those claims are worth approximately $250,000 net. There's a specific amount of money that you're entitled to in a death benefit claim, depending on how many dependents the deceased left behind. The more dependents the deceased left behind, the more possible death benefits you can receive from that work-related COVID death. And this kind of ties back to the first question as to whether or not you can get workers' comp benefits if you have received COVID. You know, you have to prove that your death was related to COVID, or your dependents, obviously, that filed a claim on your behalf will have to prove that. So those presumptions in those Senate bills will be super important so that you can meet the threshold that this death was work-related due to a work-related COVID contraction. The COVID case can be worth nothing for the people who just temporarily miss work for a couple of weeks. They receive disability payments and they return to work, hopefully 100% fine. Or you can be entitled to a settlement for any permanent impairment or death caused by the COVID related injury.
That all makes a lot of sense. Okay, so there's two different parts of that. Cool. No, good. Okay. Yeah, the final question we've got today is how long do I have to file a workers' compensation claim?
Okay, so thankfully for workers' compensation, the statute of limitations is pretty flexible. It's not a strict deadline like in other fields of law, like in civil. If you were in a car crash, you generally have 2 years from the date of the crash to file a lawsuit. And those are pretty strictly enforced. I mean, you can lose your right to pursue a case if you don't timely file it. However, in workers' comp, there's a lot of exceptions to the statutes of limitations, but generally 1 year from the time of the last workers' comp benefit that you received. So 1 year from the last time workers' comp provided you medical treatment or disability payments, 1 year from that time, generally you can file for workers' compensation claim. If you want to be the more conservative approach also is that you have to file your claim within 1 year of your date of injury. So that could make your statute of limitation even faster. But it's important if you have a statute of limitation issue to consult with an attorney, because it's complex, but you can get around the statute of limitation through several exceptions. If you want to talk to me about, a workers' comp injury that you've had that you think it's too late to file, you can go ahead and call my office and ask for me, and we could see if we can help you get around the statute of limitations issue.
Great. No, I mean that's something I've been wondering. That's okay. So you have a year. Maybe filing sooner is better than not. But if there's any questions, obviously they should come to you.
Right. I'd be more than happy to help. It's free advice. I wouldn't charge for it. You know, the reason why I'm doing this every couple weeks on a Saturday is so that I can share the knowledge that I've been fortunate to learn because I'm in this field. You know, 10 years ago, I didn't know anything about workers' comp. I didn't know anything about car accident settlements. I didn't know anything about my rights and wages an hour and overtime cases. And we live in a state that provides a lot of protection for its citizens. And we need to know our protections, especially when it comes, I think, to work protections, because all of us work. All of us have a risk of getting injured at work. The human body is fragile. You know, our body can change in a
Certainly.
moment. So we need to, I think I would recommend that, you know, we tune in or do our own research and learn the laws in regards to workers' compensation, in regards to wage and hour and overtime, in regards to job protection. You know, even though California is an at-will state, there are a lot of reasons why it's illegal to be fired in some instances. So I hope to be able to continue to give back and to provide this information. And if anyone would like to speak to me directly, you can feel free to just call my office and we can have a chat. Won't charge you anything, just want to give back. And I hope everyone enjoys their weekend. And thank you to anyone who tuned in. Thank you to you, Greg, as always. And I look forward to doing this again soon.
Absolutely. Always good to do this on the weekend with you, Belal. All right. Well, on behalf, thank you for tuning in. He said it very well there. So we're just going to head out of here. All right. Well, thank you very much. Take it easy. Have a good night.
Take care, Greg. Thank you.